Okay, thank you, Leo. This was difficult to listen to, but really rich and really stimulating. Our next speaker is Alexandre Kedar I, who teaches at the Faculty of Law at University of Haifa. Prof. Kedar specializes in land regimes, legal geography, property, legal history, and law and society. At Haifa, he is the director of the program of History and Law. He is the founding and former editor of Berg, the Haifa Law Review. He is the former co-editor of Mishpat Mushal, another law review, Law and Government. He recently co-authored, together with Ahmed Amara and Ori Fahel, I see you have it, so I'm going to show it, the book Empty Lands and Legal Geography of Bedouin Rights in the Negev, published with Stanford University Press, which investigates the protracted legal, planning, and territorial conflict between the settler Israeli state and indigenous Bedouin citizens over traditional lands in southern Israel.
Thank you. So, good morning, and thank you very much for the invitation to participate in this fascinating conference. I must say that for me too, it's a bit different move from the of the oral.
I'm sorry.
Still waiting, yeah. But what I would like to do is, in my presentation, is to offer a short overview of the debate over the concept of indigenous peoples and the attempt to anchor their claims within international instruments such as the UN Declaration on the Rights of Indigenous People, and examine the discourse over indigeneity of the Bedouins of the Negev in the context of their land struggles in Israel. And the lecture is essentially based on the book co-authored with two of my colleagues, Amara and Iftachel, Empty Lands. So basically based on my document on that. And the presentation consists of 4 parts. First, I offer a short characterization of the international national legal discourse on indigenous people during the late colonial period. I then move to show that since the late 19th century, the discourse has changed, and gradually indigenous people began to transform from objects to subjects of international law. I continue to discuss a debate over the definition of indigenous people in general and in the context of the Negev Bedouin in particular. And finally, I show that international norms governing indigenous land rights are relevant to land struggle between the Bedouins and the state of Israel. I'm not sure I will get to all of it, but whatever, I guess a little bit more time than planned originally, so I hope I can make it. Indigenous people, and just to put it in context, so we're talking about, the general question I was asked to talk about is changes of international law from the margins, and what I'm talking, the general issue is whether this has any kind of meaning for indigenous people, and maybe continuation of that question that you didn't answer about using of United Nations Declaration of Indigenous People. So, what is it good for at all, or this transformation? So, so I start by talking about the past, and indigenous people shared common problems resulting from widespread dispossession and marginalization, as noted by a recent report by the International Law Association, a leading international law group. I quote, the first the oppressor took away the land and indigenous people in line with their cosmovision had freely shared. Second, the subjugator's way of life was imposed. Third, political autonomy was drastically curtailed. Fourth, indigenous people had often been relegated to a status of extreme poverty, disease, and despair. Such processes often took place by smoothing, quote, a patina of legality on the armed confiscation of the assets of indigenous people. As part of this process, the emerging international law during previous centuries commonly served as justification for colonization and conquest. As Seth Gordon puts it, I quote, indigenous people felt the effect of the European who came equipped with the most effective of weapons, legal doctrines that would justify the taking of native lands, as well as institutionalized political, cultural, economic, and spiritual hegemony. As the scholarship of 17th and 18th century thinkers demonstrate, much of the development of liberalism in general and modern property and international law theories in particular took place with an eye on the European colonization project and still bears its imprint. John Locke, for instance, was deeply involved in drafting the Constitution of Colonial Carolina, served as Secretary to the Council of Trade and Plantation, Secretary to the Lord Proprietors of Carolina, and a member of the Board of Trade. His influential mixed labor justification of private property conditioned the acquisition of property rights upon the removal of resources from nature and combining them with one's labor, a concept suiting European settlers but in deep tension with relationships with nature characterizing many indigenous people. Similarly, in the Law of Nations, or the Principle of Natural Law, 1758, Vattel argued that the discovery of the New World gave rise to the question, I quote, whether a nation may lawfully take possession of some parts of a vast country in which there are none but erratic nations whose scanty population is incapable of occupying the whole. Those nations cannot exclusively appropriate to themselves more land than they have occasion for, or more than they are able to settle and cultivate. Their unsettled habitation in those immense regions cannot be accounted a true and legal possession. And the people of Europe, too closely pent up at home, finding land of which the savages stood in no particular need, and of which they made no actual and constant use, were lawfully entitled to take possession of it and settle it with government. As these and the additional statements demonstrate, several major, often overlapping and occasionally inconsistent methods aided colonizers in justifying the seizure of indigenous land. These included terra nullius, occupation, improvement, conquest, and relinquishment of land by treaty or purchase. For lack of time, I will address here only shortly the concept of terra nullius. Terra nullius is a legal geographic doctrine used to justify and legalize European seizure of indigenous territories across various world regions. It is not a single idea, but rather a sprawling collection of assumptions, attitudes, aspirations, antipathies. Terra nullius and the related terms res nullius, object belonging to no one, and territorium nullius, territory belonging to no one, were employed to denote several intertwined and sometimes contradictory justifications for colonial dispossession and indigenous land, territory, and sovereignty. Under the standard representation, and there are a lot of debate about in Australia whether it exists, I will not get into it now during the QA. Under the standard representation, terra nullius applied to lands unpossessed by any person or nation, or alternatively occupied by non-Europeans and used in ways unrecognized by European legal systems. In territories occupied by indigenous people, considered by their colonizers to stand too low on the development scale to have the capacity to own the land, such as Australia, the land was considered empty, waste, legally unoccupied until the arrival of a colonial presence, and thereby open for the taking. Consequently, many natives have become trespassers on their own land. Most of them have suffered discrimination and dispossession under colonial regime and upon the founding of modern states. During that era, many indigenous groups have been deprived of their traditional lands, sources of sustenance, and natural resources. During most of this period, national and international law served as prime tools in the subjugation and dispossession of indigenous people. So the beginning is not great, okay, for indigenous people. However, since the late 19th century, international bodies and powerful states and empires began to address the need to protect indigenous people. In the Berlin Conference Convent in 1884-1885 by the great powers to settle their territorial claims in Africa, participants addressed the issues of indigenous people. In Article 6 of the final act of the conference, the great powers stated their commitment to the protection, I call it protection of indigenous populations of Africa, intending mainly to distinguish them on racial basis from Europeans. Later, in Article 22 of the Covenant of the League of Nations in 1920, members took upon themselves what they term in Eurocentric terminology a sacred trust of civilization to promote the development and well-being of, again, the term indigenous people in the colonies and territories under their control. While such statements were saturated with Eurocentric prejudices, they nevertheless serve as milestones in the long, convoluted, and ongoing road of indigenous empowerment. While the evolution of international law and national human rights discourse, with the evolution of international and national human rights discourse after World War II, indigenous people started to transform from object to subject of international law. And in the book, we show how essentially indigenous people started to use these derogative terms as way to transform them into a much more powerful and give rights to them, but I will not get to all the details. Now, due to their immense diversity, there is no consensus upon the definition of indigenous people, which has consequently become a contested term. Particularly controversial is the question whether the term encompasses only indigenous in settler colonial societies, such as in the Americas and Australia, or include also indigenous people having different history, mainly in Asia and in Africa. And I want to say that indigenous identity is shaped in a mutual and ongoing interaction of forces from above and below, through legal, military, and cultural means. The conquering power, the colonial empire, and also the modern state forged for certain local groups a distinctive and subordinate local identity that differentiate them from the dominant state identity. Simultaneously, learned from their custom and struggle for safeguarding their rights and identity, these marginalized local groups developed from below their indigeneity. Thus, indigeneity is not an objective legal definition, but rather a tool in the arsenal of dispossessed groups seeking to overcome their ongoing conquest. Several scholars have coined the political use of such identity as strategic essentialism, a conscious adoption of seemingly immutable category for political purposes. This situation creates shifting and interdependent identities of both the dominant and the subjective groups. Initially, and now I get into some details about the construction of the term and the debate about the term of indigenous people. Initially, in the international context, the concept of indigenous people was promoted by and included mainly indigenous people subdued by European colonization. So this is the history. This excluded many communities which conceived themselves as indigenous, but did not experience European settler colonization, or in places where colonization has ended, although many African countries, for example. This conscriptive interpretation allowed government with other histories to endorse indigenous people's rights, while simultaneously claiming that emerging international definitions do not apply to their states, since it did not include any indigenous population, or alternatively, that all or most of the population was indigenous to the land. So you can see here a kind of unholy marriage between indigenous people from Australia and America and political government from Africa and Asia to exclude indigenous people from these regions. Very interesting, this kind of. So I'll give you some examples. So we have a quotation from China in 1995 to the UN. Indicative of what came to be known as the Asian controversy. So, for example, China stated that, I quote, "The Chinese government believes that the question of indigenous people is the product of European countries' recent pursuit of colonial policies in other parts of the world. Because of these policies, many indigenous people were dispossessed of their ancestral homes and lands. these various nationalities in China, on the other hand, the various nationalities in China have all lived for eons on Chinese territory. Although there is no indigenous people question in China, the Chinese government and people have every sympathy with indigenous people's historical roots. And it continues. The government in India argued that the concept of indigenous people could not apply to India because after centuries of migration, absorption, and differentiation, it is impossible to say who came first, and because 300 to 400 million people in the country are distinct in some way from other categories of people in India. And other Asian governments expressed similar view. I quote, Indonesia is a nation which has no indigenous people, or all Indonesians are equally indigenous. All Bangladeshis are indigenous people who existed in the territory prior to British colonization are now fortunately liberated. Similarly, several African countries objected to the expansion of the concept beyond the settlement colonies. A 2006 press release from Botswana Presidential Office stressed all black Africans are from African origin. We did not emigrate from elsewhere to Africa. We have always belonged here, so we don't have indigenous people. However, Asian and African communities increasingly identify themselves as indigenous. Indigenous people from around the world attend the World Group of Indigenous People annual sessions. Among those attending are community representatives from states denying the existence of indigenous community within their borders, and generally, and I will not have time to talk about, many local and regional courts recognize people in these places as indigenous people. So there is a change. By 1982, Sweden, Norway, and Finland acknowledged that the Sami were indigenous, thereby establishing a precedent for recognizing groups as indigenous, even in states where the majority of population is itself indigenous in the sense of a homeland community, or at least very, very old. And gradually, the concept of indigenous people expanded to include indigenous and tribal peoples not colonized at all by European states or colonized by the past, but living in states dominated by groups considered native to the land as well. Writing in 1988, Benedict Kingsbury noted that in ordinary language, the term indigenous connotes priority in time, if not immemorial occupancy. However, over the last 20 years, when he's talking of 1988, the concept has undergone a semantic evolution that brought it far beyond its original meaning. In terms of the term indigenous people evolved out of its original denotation to become a distinct and separate international law term. Adherence to its original denotation thus constitutes antiquated and inaccurate utilization of the current legal term. In line with Kingsbury's approach, a substantial group of scholars argue that contemporary designation of indigenous people are considerably wider than the exclusive question of primordialism. While the settler colonial temporal priority criterion usually works in the settler states, it also not a clear-cut benchmark. Often it is practically impossible to determine the exact chronology and priority of different groups that reside in the territory, especially in the case of oral communities and the use, that's maybe how I can relate to this debate and during the Q&A. The use of oral and the issue of evidence is critical in these issues, especially of land rights and what was here first and so on. So instead of looking of prior occupancy and the history of settler colonialism, current scholarship and international approaches stress the subjugation of autonomous cultural groups by the modern state. Based on a long review we did on a book of scholarship and regional national courts decision that I skip here, I suggest some common though not exclusive characteristic thread of who is indigenous today, and these include a strong emphasis on self-identification, the existence of distinct identity and custom, and strong and long-term attachment to a particular territory, lack of domination, and a history of subjugation, dispossession, and marginalization. To these, one can add several non-exclusive characteristics such as tribal social structures. It is now turned to the question whether the Bedouins of the Negev can be considered as indigenous people according to international understanding, and this also is a huge issue. I will not have time to get into it, but I will just give some of the outline of the discourse. Like many other groups, Negev Bedouins' identities are multifaceted and dynamic. The Bedouins of the Negev are part of a tribal society, include several confederations and many tribes, which inhabit for generations the region comprising today the state of Saudi Arabia, Jordan, Egypt, Israel, and the West Bank and Gaza Strip. After 1922, with the demarcation of the borders of Mandate Palestine, they became geographically and gradually also socially associated with the Palestinian Arab entity, even while the political borders remained loose. After 1948, those remaining in Israel became Israeli citizens and part of the Palestinian Arab Israeli minority, while the rest became refugees in nearby countries and in the West Bank and Gaza Strip. Although they stress their particular history, geography, and culture, the Negev Bedouin struggle over the indigenous rights is simultaneously a segment of a larger Palestinian journey to anchor the nation's native and national rights in the region. So at least my concept is that identities are not exclusive, but we all have multiple identities. To further complicate the story, one should remember that the Israeli state argued that the Jews, especially the Israeli Jews, consider themselves and should be considered by others as indigenous to the land of Israel and display strong, often spiritual and cultural connections to this disputed territory. Israel denies Bedouins' indigeneity partly because of its claimed Jewish priority in the land. So, like many other identities, Bedouin identities are at least in part constructed and relational. My approach, inspired by critical identity theories, demonstrates that identities are constructed and reconstructed within specific historical and social contexts. Indeed, as Albert Barume recently remarked in the context of Africa, I quote, "No community was born indigenous. Certain events prompted some communities to use the term indigenous people as a way to claim specific denied rights. Had those events never occurred everywhere, the concept of indigenous people, as currently understood in international rights law, wouldn't have existed. There would be Maori, Aborigines, Mayas, Yanomami, Batwa, San, Maasai, Ogiek, Sami, and others, but they would not need to self-identify as indigenous people as a way to seek justice. It is not surprising, therefore, that similarly to other indigenous communities around the world, the Bedouin adopted a discourse of indigeneity in the context of contemporary development in international indigenous human rights, as well as in conjunction in their struggle for recognition and protection of the land fight against the recent Israeli measures to dispossess them. As review articles demonstrate, most scholars currently conceive the Bedouins as indigenous group. However, this is not a consensual approach. Interestingly, the major challenges come from two opposite directions, from some Palestinians, including Bedouins, and from Zionists. Some nationalist Palestinian scholars and activists reject the exclusive assignment to the term of the Bedouin because it implies a potential separation of the Bedouins from the rest of the Palestinian people, and might undermine the Palestinians or the Palestinian citizens of Israel claim to indigeneity, because many Palestinians claim that they are all indigenous to the land. My argument that we will have time to talk about, I make a differentiation between indigenous people in the narrow sense as used by the United Nations Declaration of Indigenous People. It's not defined there, by the way it's used there, and international generally, and the term whether a person is indigenous to the land. I call these people part of homeland communities, and I make a distinction, but I will not have time to talk about it much. Anyhow, also some Bedouins express unease over the identification with the term as they are associated with primitive characteristics, so they don't want to be part of this indigenous group. There have been recent attempts to situate Bedouin history within the history of the Palestinian people rather than on the discrete tragic story of nomadism to modernity. Essentially, I think, as I said, that there are multiple identities, but legally on a doctrinal definition, I think my position, which is controversial, is that the Bedouins are indigenous people and other Palestinians are not. Okay, there are people, but they are not an indigenous people, they are nation. There are many other things, but they are not in the narrow sense. It's very controversial. We couldn't agree on it on the book, so it's out of the book. On the other hand, that's also interesting. Both the formal Israeli position as well as that of a group of scholars that are fighting the Bedouins of Bedouin rights are that the Bedouins are not an indigenous community. The state of Israel denies Bedouin indigeneity in court proceedings as well as in national and international arena. For example, Ehud Praver, a leading figure in drafting state Bedouin policy, argues, I quote, the attempt to claim that the Bedouins are an indigenous group in the Negev is very problematic. Not only is it historically inaccurate, but it also creates an unnecessary antagonism and transforms the Jewish people in the region into invaders, which contradict the fact that we have returned to our own homeland. We were here first. So the book also shows that Bedouins fit many of the current characteristics of indigenous people. They are not less indigenous than many other indigenous people in Africa and Asia, even if we don't get into the settler colonial paradigm. We don't need, according to my understanding, we don't have to have a settler colonial state in order to have indigenous. I make the distinction, but I also think that Israel is a settler colonial country, but that's for another discussion. But anyhow, I don't need it in order to argue that the Bedouins are indigenous, and they fit the prevailing four major criteria. They self-identify as a separate indigenous community, most of them. They preserve a distinct identity and custom and possess a long history of societal self-rule. They display a powerful and long-term attachment to their land and historical territories. And they have a history and a present of subjugation, dispossession, and marginalization, and they also continue to hold very powerful tribal social structures. So I think that they certainly fit this structure and concept of indigenous people. Now, in the last 2 minutes, so I return to the same question I asked. What's your name? Ramute. So what's the big deal? I mean, so okay, let's say they are indigenous. What does it make a change? Whether it make a change at all? And we don't have a European Court of Justice. We don't only have our Supreme Court, which is horrible in respect to Bedouins. It's a catastrophe. So what's the big deal? And I was involved in a case that reached the Israeli Supreme Court arguing that Bedouins had land rights and were indigenous and so on. And it was all thrown out of the door without any problem. So what's the big deal? So I think that it's a question of alternatives. And the United Nations Declaration of Indigenous People, and we argue in the book that part of it are already part of customary international law. And if they are part of customary international law, formally they are part of Israeli internal law, unless they contradict statutes. So, first of all, there is a very strong possibility to criticize. Essentially, I think that the Israeli court is ruling against the law. Now, of course, it's not very helpful, as the court does similar things in the occupied territories and so. But I think that when you think about the alternative, what you do, I think that the Bedouins have really now in Israel two alternatives. Either cling to the land, and they do it, or internationalize the dispute. And moving into it, so it's really a strategic move to say we are indigenous, and we want to have the protection of indigenous people. And the only thing that has some kind of influence as Israel is actually these things that here I will end. For example, in occupied territories, Israel is trying to move a group of Bedouin that were removed first from the Jahalin, who were first removed from the Negev, then to the several parts in the occupied territories, and the Supreme Court allowed it, and everything is fine. But the only reason that doesn't really happen is international pressure. And I think that the discourse of international law can be effective and